Fuller here. Dutton, Steinberg?
Here.
Steinberg here.
A quorum has been established. We expect the other members to be here momentarily. Today we have 4 governor's appointees who are appearing today, all appointees to the Board of Parole Hearings. And I would like to ask all 4 of you, if you would, to come on up at one time. We do have 4 chairs there, 2 mics, so we'll see what the spirit of cooperation and collaboration is like at the board. I want to welcome Cynthia C. Fritz, Howard E. Mosley, John Peck, and Terry L. Turner, all up for confirmation, again, as members of the Board of Parole Hearings. Welcome. You guys, let's turn that around if we can, Jody. Thank you. Appreciate it. Very good. I want to welcome you all to the Rules Committee. It's a very important part of the process of serving in the executive branch of government. And we want to use this opportunity to get to know you and have the public get to know you a little bit, to ask some questions about your public responsibilities and to go from there. So why don't we begin with asking each of you if you would introduce any friend or member of your family or special guest who is here, to make a brief opening statement, and then we will commence the questioning among the members. All right? Who wants to start? Ms. Fritz?
Sure.
Why don't you take that mic and just, you can pull it over. It's got plenty of slack. Very good.
All right. I don't have any family members or friends present today.
Okay.
Good afternoon. Thank you for the opportunity today. When I took this position with the Board of Parole Hearings, I had a personal goal in mind. And my goal was to provide, and still is, to provide fair and objective hearings to inmates going through the parole suitability process. That includes upholding the law, being respectful to all the parties and participants, and maintaining professional decorum through the hearing process. And throughout this process, at the same time, preserving public safety. Thank you.
Thank you. Mr. Peck?
Thank you. My wife is here, Janine, and my parents, Tom and Shirley Peck.
Well, welcome to you. Welcome to the Rules Committee.
Mr. Chair and members, I want to thank you for the opportunity to be here today. Being a member of the Parole Board for the past few years has been one of the most challenging positions I have held. I am fully aware of the responsibility and weight that accompanies the position of BPH Commissioner. Each and every case I preside over involves hours of preparation and hours in the hearing to make sure all the evidence is appropriately weighted in order to reach the best decision for public safety. It's my pleasure to answer any questions you may have, and thank you again for this opportunity to continue to serve.
Very good. Thank you. Y'all get points for short opening statements. Very, very impressive. There we go.
Mr. Chairman and members, I'd like to proudly introduce my son, Taylor Turner, who's in the back there.
Welcome.
The pastor of my church, Pastor Carl Carter, and his wife, the First Lady, Deborah Carter.
Welcome, Pastor and Ms. Carter.
And my friend and deacon of the church, Brother Donker.
Welcome, Deacon. Okay.
And it is my honor to appear in front of you here today for this confirmation hearing. My education, my 30 years of criminal justice experience, being a proud mother and grandmother, and a member of a wonderful church, my faith in God gives me the ability to make fair and impartial decisions on a continuous basis. I worked 3 years as a deputy commissioner, retired and knew it since I had the experience of working in life affairs prior to the appointment to the commissioner, and it's my pleasure to continue serving in that stead. Thank you.
Thank you.
Good afternoon. My name is Howard Mosley. I'm also honored to be considered by the Senate Rules Committee for this position. My public service career began with a 4-year stint in the U.S. Army. After graduating law school, I went to the Attorney General's office, where I was a prosecutor for 8 years, and then followed that with 6 years at the Inspector General's office, gaining some familiarity with CDCR. I joined the board last August, and I recognize, like my fellow commissioners, the importance of this role to public safety. Again, I thank you for your consideration today.
So I think what the committee would like to hear, and I know you've had conversations with many of the members, but really is your philosophy, if you will, and how you approach these cases. Talking about people who usually have committed, obviously, very serious crimes, murder, and you're making a recommendation as to whether or not they should be eligible for parole. And you each have different rates of parole grant and denial, and that may mean something, it may not mean something, because cases are fact-specific. But how do you do your job? What are you looking for when you make a decision to grant or to recommend the granting of a parole for someone who has committed a murder?
Well, I can tell you I approach each hearing on a case-by-case basis because, as you indicated, it's very fact-specific. There are a number of factors that we must consider as required by the law and by regulations. But we also, of course, consider the person that's in front of us, the comments by the district attorney's representative, any victims or victims' next of kin, and the extensive reports that are prepared prior to each hearing. So I know for each of us there's a considerable amount of preparation, and there are a lot of interested parties who need to be heard and deserve to be heard before we reach any kind of decision. And so the basic approach is to consider all that information, balance it all, and try and reach a fair decision.
Thank you. Please pass the mic on down there, if you would.
Well, I think that Mr. Mosley did sum it up pretty well. We do it case by case, and we look at all the factors prior to making a decision of suitability or non-suitability. And it's a challenge every single time.
The preparation for the case starts well in advance. Usually we get the cases a couple of weeks in advance, go through the files. Usually we'll spend hours in reading the files, find out what the particulars of the case that are involved in, establish a line of questioning, look at some issues that may be of concern and address those issues when we get to the hearing. Each hearing usually takes a couple of hours. What I like to do is try to figure out if the offender has connected the dots to what brought him to prison in the first place. I think that's really important to see that they have addressed their issues, also to see what kind of involvement they've had as far as any kind of rehabilitative programs that are offered, see if they've made those connections right there, and see if they're able to follow the rules of the institution and the other factors that are involved in 2402, and make the assessment with my partner, the Deputy Commissioner.
Thank you. Ms. Fritz?
Thank you. I think ultimately we're trying to get to the determination of whether the inmate is currently dangerous, and in order to do that, it's different for every inmate that comes to the panel, because every inmate has their own story and reason for being incarcerated, and they have different ways of going through the process. But ultimately, it's current dangerousness and public safety. And so, although there are a number of factors that we weigh, including disciplinary issues while they're incarcerated, their programming, how they feel about the life crime, and their prior criminality, as well as what type of social situation they have upon release. Every inmate has different issues, and those are the issues that will be weighed differently for each inmate accordingly in order to come up with that determination.
Let me ask my colleagues to probe in even more detail. Senator Alquist.
Thank you, Mr. Pro Tem. My first question will be for Ms. Fritz and Mr. Mosley. I should say to begin with that I enjoyed the conversations with all four of you in my office, and I think we had some in-depth discussion, which was of great help to me. So, as commissioners, you travel every week to different prisons. In assessing whether or not a life inmate is suitable for parole, you consider the ways in which that person has rehabilitated himself, herself. As you have a more macro view of the prison world than those who spend every day at the same institution, what type of best practices and programs do you see that rehabilitate prisoners, and what does work well?
Well, there's a lot of different programs at the different institutions, and some more than others. I think the ones related to sobriety are very important because there is just a large number of inmates that come in with drug and alcohol problems. I've been very impressed by the substance abuse program and also the mentoring program that they have at Solano. They also have the SAP program at Avenal. So I think that's a really important program. But there are also so many other programs. They have programs for inmates that were previously involved in gangs and are going through debriefing or want to disassociate. They have alternatives to violence. There are programs that inmates can look into to deal with the specific issues that they have, such as domestic violence and things like that. So there are programs out there. Like I said, it varies from institution to institution on how many they have.
Thank you.
I would agree, of course, with everything that Commissioner Fritz just described. I would probably add that those institutions that have a good relationship or partnership with the community and many volunteer programs benefit from those. And so we find more opportunities when those exist in the prison. I would also recognize some of the therapy programs that the mental health clinicians operate in many prisons. Those are also instrumental for those inmates in beginning to understand their issues. So those two I would highlight in addition to the ones that Commissioner Fritz just described.
Thank you. I had visited several prisons, and many years ago, probably in about 1997, 98, I visited Pelican Bay and sat in on a class for lifers on English and composition, and I found that very interesting as I did talk with some of the people in that. Okay, so just a follow-up question both to Mr. Mosley and Ms. Fritz, and we'll start with Mr. Mosley. Just very briefly, how do you share best practices, and what type of process is there for you as a commissioner to say, for example, this particular program at California State Prison should be replicated, or I suggest that it be replicated at other institutions?
Well, we've recently, through the board, instituted some committees, and through those committees we hope to do exactly that. Identify what we believe are good programs, and then find a consensus among the commissioners who've experienced some of the inmates who participated in those, and then through that committee and the full board, then perhaps make a recommendation to CDCR so that they might take that lesson learned and apply it elsewhere.
Thank you.
And I agree with that. Also, I'd like to add, we also, when we find programs that are successful in certain institutions and we don't see them in other institutions, you can go and talk to the staff at the institution. You can go in and talk to the principal like I've done before and talk to them about, I've seen this type of education program over here. What do you think about starting it here or in some different capacity? And, most of the staff members that I've come into contact with are very open about wanting programs at their institutions.
Thank you. Now, for Ms. Turner and Mr. Peck, what I'm going to ask may not be exactly in your purview, but I think it's worth having the discussion in the public about. This is my 14th year representing Santa Clara County in the legislature. I could talk to you about the demographics, the major employers, the people, the spirit of the communities, neighborhood characteristics, a lot of information that allows me to hopefully serve my district well. How well do you know the population you are working with? In other words, do you know what percentage of lifers are gang members or grew up in poverty or committed a single crime of passion or can't read or have dyslexia? I think this is a harder question, and as I said, it may not be exactly in your purview, but I think it's worth discussing because in order to reduce the recidivism rate, I think we need to figure out exactly what has driven people to become lifers.
When we see an offender,
And that was the last question.
Okay, when we see an offender that comes to us, one of the things that we do want to go over is whether they're literate or illiterate. I mean, that's part of our ADA or our Americans with Disabilities Act thing to do. We want to make sure that they are literate. As far as global gang affiliations, we certainly can find that information out for you and through the board, and we can get that info. But there is some, I mean, is it street gangs? Is it prison gangs? Is it, there's a lot of different, is it, local gangs or, and I think that kind of has a little bit to do with it. As far as when we see the offender that comes before us, we definitely, if there is some notations that has them involved in any kind of gangs, we definitely want to address that, and we want to find out if they're members of the gang or if they're associates of the gang. We want to kind of find out their involvement in the gang, and if they've disassociated themselves from the gangs or if they're still involved in the gangs. Obviously, if they're involved in gangs, that probably is a pretty big concern to us, that they haven't disassociated themselves in their criminal behaviors. So that, as far as gangs go, we do look at it, but it's more of a case-by-case basis by the offender that's coming before us. And the same thing with substance abuse and all those other issues that we look at, literacy, education. One thing I can say about education is I would say there is a large amount of people that appear before us that, when they were in the community, did not have a high school education, that they were high school dropouts. I mean, that's something that I see regularly. High school dropouts, many of them have continued their education while they've been incarcerated, but while they were in the community, not a lot of vocations, not a lot of education.
And certainly I should have included mental health in the categories. Ms. Turner?
Well, I don't have any statistical information as it relates to the various backgrounds of all the different cases we see, whether they come from poverty, whether they are one-time criminals or history of criminal. I think we see a little bit of everything. We see folks that pretty much have been raised by the criminal justice system, starting when they were 12, 13 years old in and out of juvenile hall, up into the current life crime. And we've seen other cases that were doctors and lawyers and that kind of thing, and they had only the one life crime, no other criminal history, or no social maladjustments or anything like that. So it's pretty much case by case, and we have the information available to us, and we utilize that as part of our decision-making process.
And whatever information you can get to us through our chair would be helpful also. Thank you very much.
Thank you.
Thank you.
Thank you very much, Senator Alquist. Senator Fuller?
I have one question for each of you, more or less. So let me start with Ms. Turner. We were reviewing some of your transcripts after the discussion we had in the office, and you said that you looked at how an inmate has progressed since being incarcerated. When reviewing a case and you see an inmate who has progressed, how do you weigh that progression against the seriousness or severity of the original crime?
Well, the one thing that I keep in mind is that the original crime doesn't change. The facts of the crime doesn't necessarily change. So you have to look beyond that and try to determine whether the person fixed whatever the issues were they were having in the community that led up to the commitment of that crime. And part of that is by looking at the number of hours of participation in various programs that are offered through the institution, as well as the amount of time independent study where they might read books, they might do book reports, they may do outside stuff, religious practices and religious programming. So you look at all that combination and you use your best judgment and criteria to make the determination of suitability or non-suitability.
So I know it's a really individual determination for each person, but is there like sort of a general threshold you sort of look for, or you begin to feel more comfortable when you get to that overall?
I don't think so, because you have such a broad group of people where some are very educated and some are not. So the expectation has to be individualized. I mean, I don't know that you can group them.
Okay, thank you. Ms. Fritz, we discussed a little bit the psychological evaluation. What other factors or tools do you use to help you determine suitability?
Well, the psychological evaluation is one of many tools that are used. We have a large amount of information that we use with all of their pre-conviction factors. So the static factors such as their life crime, their prior criminality, all of the social factors that were in their life that led them to the commitment offense. So that's taken into consideration, along with all their institutional behaviors, such as not only their programming, employment, education, vocations, and really looking at that in comparison to where they were prior to the life crime, because as everybody has said, it's all individual. So some of them, getting a GED is a huge progression for some, while others already come in with a high school diploma. We also look at their disciplinary history, mental health, whatever issues they had at the time of the commitment offense. And then also looking at what type of support they have out in the community. So are they going to be programming out in the community? Do they have somewhere to live? Do they have family support or friends? Because certainly being stable upon release is a better formula for success.
Mr. Mosley, in reading through some of your hearing transcripts, there was one or two instances where, sorry, I have to look around her head one way or the other here, where I wasn't completely sure that maybe you were sort of trying to convince them a little bit to stipulate to, they wanted to stipulate to unsuitability to have a hearing, but then you sort of, I couldn't tell if you thought that was better going to stipulate or not stipulate, or would there be circumstances in which you would think that there would be a better reason for them to stipulate than not stipulate, or how do you handle that whole decision-making process?
Well, with regards to stipulations, that would first and foremost be a discussion between the inmate and their attorney. Mm-hmm. And it would be for them to propose a stipulation to the panel. It certainly isn't my practice, and I'm unaware of any commissioner's practice of encouraging stipulations. So that's a decision for the inmate to make with advice of counsel. And the board's position, certainly my position, has been to encourage hearings. It's an opportunity for them to learn about the issues that may be still there in their record. They may gain a better understanding of what they should be focused on during their incarceration to improve themselves. So, I'm unclear on which particular transcripts, but it's certainly not my practice to encourage stipulations. But maybe your question goes to when a stipulation is proposed, what kind of factors we might consider in accepting that.
Question, yes.
And so when a stipulation is proposed, obviously there are interested parties again. There's the inmate and their attorney, the district attorney's representative, and sometimes there are victims or their next of kin. And so before accepting or approving a stipulation, it's important to hear from the parties, hear their input, and oftentimes the factors that are described by the inmate in requesting the stipulation is a need for more time to work on parole plans, something that might be acknowledged by looking at the record where there are none. They might ask for more time because they haven't really worked hard on their substance abuse or drug problem, and we can see from the record that, in fact, they only began a program like AA 6 months ago. They may recognize that they have disciplinary issues, even violent disciplinary issues, that arose in the last year or two, and so they might ask for more time because they obviously need to consider an anger management class or a conflict management class. So those are the kinds of issues that will be discussed in considering whether a stipulation will be approved, and if so, for what duration.
And part of what prompted this question also was, according to the statistics we were given, that stipulations of unsuitability, you had sort of a slightly lower number than others and a slightly higher percentage of parole grantees of releases. But I understand that there's a very big difference between which prison type population you're working with. And so I'm just trying to find how I get at that question for you to, like those statistics, if you're a little higher releasing and you have a little lower number of stipulations of unsuitability. So I went through your transcripts and was sort of trying to figure it out. So if there's anything else you'd like to shed on that to help me, I'm still struggling a bit with that.
It is challenging because each institution is at a different level, and so their programming levels are different, and the inmates that are housed there are different as a result because of the classification score they may have. So it does impact your global statistics depending on what assignments you have for institutions. It's a very different week if you're hearing parole suitability cases at Avenal State Prison or at the Men's Colony in San Luis Obispo than if you're conducting hearings at Pelican Bay or at Corcoran. So obviously time spent at each of those institutions has an impact. But I think one of the things that's reassuring in the process is knowing that it's not a one-person decision. So over many months of conducting hearings, there's always been a deputy commissioner or a fellow commissioner when we're teamed up together who are hearing the same information, and then during deliberations we have a very open, honest conversation with each other to determine what we think are the most important factors and ultimately determine if public safety would be jeopardized by a release. And so after that conversation with commissioners who generally have more experience than I do, having just recently joined the board, or even deputy commissioners who've been practicing for a decade, it's an important part of the process to have that conversation, reach a consensus, and then announce the decision.
Well, just as just a little caution, in looking at the statistics, of course the parole denial was also lower than some of the others. So I'm just having Tehachapi prison in my area, which has some very violent offenders. I just really hope to get to the bottom of that question, and I appreciate your trying to educate me a little bit on that factor. I'll move to Mr. Peck briefly, because I've certainly taken a lot of the chairman's time, and I appreciate the time.
No. Take all the time you need.
Thank you. But one of the things that I'm interested in is, as I looked at your background, one of the things that was more unique about you was that you have a law enforcement background. So how do you feel that a law enforcement background affects your decision-making in this role, either positive or negatively or in general?
Well, I started off as a correctional officer. So I'm from the prison world.
Oh, okay.
And so what has helped me is I've been talking to offenders since I was very, very young. Mm-hmm. So it's made it easy for me to have good communication with the inmates. And that's one of the things that I think I'm relatively effective with, is I have good communication with the inmates. I can establish a pretty good rapport with them. Sometimes you have to speak the language they speak in order to get to really assess whether they are still a current unreasonable risk of dangerous or whether they're ready to go. And, I've spent a lot of time with inmates when I was working inside the prisons. I've spent a lot of time working in the camp programs. I've been pretty much in every level that you could ever imagine inside the prison system. And many times I've come across an inmate that has that light bulb moment when he really realizes, this is not really the life that I want to live. I don't want my legacy to be dying in prison. And that's really helped me because I've watched how they've done it in prison, where they've started getting involved in more programs. They've started taking AA programs, and they were always really resistant. I don't want to go to that program. They're just sniveling, crying in there. And then all of a sudden they get involved in that program, and they start getting involved, and they start bringing that in to heart. Mm-hmm. And, because of that involvement with them, it's made it easier to make that assessment while I'm dealing with them as far as being a presiding commissioner.
Thank you. Can I go back to Mr. Mosley for just 1 minute? So has there been any opportunity for you to sort of track and watch for recidivism or problems with the population that you released at all, or do you have any comments on that?
Well, during the 7 months that I've been conducting hearings, most of those cases are just now either reaching the governor's office, or perhaps there's a month's worth that have passed that stage. So there isn't a population basis out there for me to look at. However, having said that, of course, there's a huge population of lifers that are out there from my hearings and colleagues' hearings and in the past. And ultimately, living in a community like everyone else, public safety is the paramount concern. We want to know that they're going to successfully transition, that they've internalized enough of the lessons while incarcerated so that lifestyle is something they're going to turn away from. Because without that, whether it's your community around Tehachapi or my community near the 2 prisons in Folsom, we're all concerned. And so that leads to very lengthy hearings, very in-depth hearings, because you want to be as confident as possible that this individual does not pose a current dangerousness if they're released. And so that is the legal test, that is my test, that's the point and the thrust of much of the questioning that occurs during a hearing.
Thank you.
Thank you. Just to follow up on Senator Fuller's question, we've returned it to Senator Dutton. Good questions. In terms of, because we all try to explore, as I said earlier, what's the philosophy, what's behind the record here in terms of the statistics. But I just want to note for the record, Mr. Mosley, you were a prosecutor, correct?
Correct. I've sent people to prison.
Right. And what years were you a prosecutor? In what capacity?
I joined the Attorney General's office in 1996, and I was there for 8 years.
And your job was to do what?
I was on the trial team. And basically, when a local district attorney either recused themselves because of a conflict or a Superior Court judge recused the office because of a conflict, my team would send one of our members to that county to prosecute the case in place of the district attorney. So I've appeared in everywhere from Kern County Superior Court to Siskiyou County Superior Court on behalf of the Attorney General's office, handling everything from misdemeanors to felonies to murder trials to death penalty cases.
Thank you. Senator Dutton?
Well, maybe just a couple of questions, if my voice will hold out. Let's see. Let's talk a little bit about medical parole, because that's something that's relatively new. It was by legislation introduced by Senator Leno last year. How's that working? And I'd like to get all of your perspectives. But let's start with you, Mr. Peckby. You've got the most experience.
I've done medical parole hearings. It's a good process. There are some challenges sometimes with the process, especially when the inmate doesn't sign, where we have to do confidential tapes because he hasn't signed his medical disclosure forms. But it's not a long process, but you want to find out if the person poses a current unreasonable risk of dangerousness to society. That's pretty much what you're doing right there.
But are you, right now, the protocols and everything, I guess, are put into place. You currently have a system, right?
Yes.
And right now, I think we've released, there's been about 30 cases or releases as a result of that. There's been about, I think, 4 or so that have not. I'm really interested in hearing from the rest of you, too, how it's working. Is there things that need to be addressed that aren't? Do you have the information that's necessary? Are you getting honest assessments? Are you?
I'm pretty comfortable with the process. I did the very first one, and I've done a few in the past, so I'm pretty comfortable. I think we have enough information to make determinations.
Okay. How about Mr. Turner? I think you look like you want to talk about it.
Well, I was just going to say, I think I probably have conducted about 6 of them. I haven't had any issues with it. If someone had a recent disciplinary that has some kind of violence, even though they have the medical issues, but they're still able to, hit at or spit at, then those might be reasons of not granting a medical release. But for the most part, the information's available to us, and it's a pretty simple hearing because the inmate is not present. So you have the representative from the district attorney's office, and you have the inmate's attorney present, and then you have the commissioner and the deputy commissioner. So it's been a pretty, I think, simple process.
All right. Mr. Mosley, do you have a
I've also performed medical parole hearings. They can be challenging in the sense that you get into very specific information about their medical condition. You want to understand very clearly what mobility they have. Do they have the use of both arms? What type of crime do they commit? And do these physical impairments suggest that they would not be capable of repeating that criminal activity, or are they still capable of repeating it? So you get into very specific information based on that medical record, but it's necessary to do that to understand what the likelihood would be of a reoffense, and that's, of course, the important question.
Of course, the dangerous society is not always due to physical capability. Sometimes it's mental capability that actually.
Can they physically make phone calls? And was their original crime one based on threatening conduct? Can they solicit the assistance of others to commit crimes? Was that something that they've exhibited a pattern of behavior in the past? And so you're absolutely right. It's not just the physical capacity to go out and commit a new crime. It's very dependent on the type of criminal pattern they demonstrate and what, if any, mobility or communication they can continue to perform.
So you do take a look at the behavioral part of it, not just the physical impairment, but also, you do take a look at.
Correct. Not just prior criminality, but the life crime as well as behavior while incarcerated.
Mrs. Fritz, do you have anything you'd like to add to that?
Sure. I've done 2 medical parole hearings. I haven't had any issues with them as far as the actual procedures. In both cases, they signed waivers so that their medical information was before everybody. I do understand, though, and that it would be difficult, not for the panel, but for the other parties involved, such as the district attorney's office and the inmates council, if trying to advocate for their side without having the medical information before them.
Okay. Mr. Mosley, it's been suggested that because of your prior work that you did with Matt Kate, that perhaps you may not, that may somehow influence or have some kind of a reason for why we should maybe discount your consideration for this position, that somehow your relationship with Matt Kate might be too much of an influence.
Well, I worked with Mr. Kate at the Attorney General's office. We were both Deputy Attorney Generals. And when he was appointed Inspector General, he asked if I would join the Bureau of Independent Review, and I took that appointment there. I worked for other individuals, my direct supervisors, though Matt Kate, of course, was the Inspector General. He left the Inspector General's office to go to CDCR as Secretary. I remained at the Inspector General's office and then came to BPH subsequently and apart from Mr. Kate. I certainly always had good relations with him as a colleague at the Attorney General's office. I perceive my role at the BPH as that of an independent hearing officer. And so in each case that I hear, I'm looking at the case record, I'm considering all the input of all the interested parties, and there's really no external influence, whether it be from the Secretary of CDCR or the Executive Officer of BPH or the Governor himself, that I believe should have any part in my hearing decision.
Okay, thank you.
Senator De Leon.
Thank you, Mr. Pro Tem. I think this question may have been asked, perhaps different variations by Senator Alquist and Ms. Fuller. It'll be sort of open-ended question to sort of understand your thinking. I know that, Ms. Fritz, you have here 151 cases that you have reviewed according to this chart. Mr. Mosley, 118. Mr. Peck, 261. And Ms. Turner, 232. And your grant as well as denial ratio or percentage, more or less, are very similar, although your universe, if you will, of the actual parolees that have come before you do vary, particularly with Ms. Fritz and Mr. Mosley, I think, because your recent appointments. The question I have is that one of you had mentioned this aha moment, you know, Mr. Peck, and give us your perspective of the aha moment. How can we get more aha moments? You know, because aha moment seems very individualistic, and if it could be systematic, more so. Aha is sort of kind of like a great script for a great movie. You know, someone's as a lifer and there's an aha moment, and you know. But how can ahas become, you know, more part of the culture and more systemic? You know, and I know that it's very difficult given the fact that there has been very severe budget cuts. So with regards to counseling, regards to addiction issues and other anger issues that all the stuff that one carries inside that have yet to work out and take accountability and responsibility for his or her own actions, give us some examples that you think would increase the numbers for individuals.
Well, I'm part of the Rehabilitative Program Subcommittee, so that's, and I'm also part of the training committee. But I really believe in the rehabilitative program. I've been to quite a few of them at the prison system, and my experience with the inmates or the offenders that have been incarcerated has been, most of them, not all of them, but most of them, when they first come to prison, they have a very difficult time. It's a tough adjustment, even though especially when they're incarcerated on an indeterminate sentence. And so you find that their disciplinaries are higher, their involvement in disruptive groups are higher. They have a difficult time making the adjustment. Sometimes when they go to their doc hearings, they start getting some suggestions from the commissioners, the deputy commissioners, when they tell them these are some of the things that you really need to do. And sometimes that'll start the wheels turning in their head that, maybe I need to start looking at what I did in the community for me to start seeing how I can change my behaviors. Sometimes, absolutely, that does not work. When it starts getting closer to their dates, though, some of them start to say, maybe I know I need to get involved in some of these programs. Like maybe I'll just jump on an AA class right now and, just get them to sign the little form for me so I can at least say to the board when I go there, look, I've got the little magic golden ticket here that says that I'm into AA. Many of them, when they first start going, it doesn't really take hold yet. But there comes a time when all of a sudden, sometimes it's their initial hearing, sometimes it's before their initial hearing, where they'll go, maybe I really don't want to be in this kind of environment anymore. Maybe this is not really what I want to do. And so they start getting involved in criminals and gangs, anonymous classes. They'll start getting involved in NA classes. They'll start getting involved in AA classes. They'll start doing anger management classes, the Bridges, all these programs that we have that are out there that these guys get involved in, and they start listening, and then the aha moment happens. All of a sudden they start getting that moment of, gee, something, maybe it was my fault why this life crime happened. Maybe I was the reason why, because many times you talk to these guys and they're going, something, I didn't do it. I was there, but I watched it, but I didn't take the opportunity to stop it. But something, I wasn't the guy that pulled the trigger. But something, after a while they start taking these classes, they realize that because of their behaviors, they were exactly involved in what happened in the life crime. And that is the aha moment. We got to get programs out there for these guys. We got to get these guys out there at least to start looking at themselves so they can start addressing some of the issues that got them to prison. Because from what I've experienced is that as long as they're still in denial, they're having a very difficult time in addressing, the things that have been wrong with them to get them to prison.
Ms. Fritz, Ms. Turner, Mr. Mosley?
Well, one of the things I've noticed, and I've only been doing the commissioner position since August of last year, but I did have the 3 years of deputy commissioner experience. One of the things that I've noticed is hope. I think for a long time there was no grants given, so folks had given up. So inmates didn't put a lot into programming because they figured they were never getting out of prison anyway. And as they see the grants going up and they see people actually get out, then I think there's some hope. And I think when you see hope, you see programs, because now they've realized, I need to do some things, but at least I see, a light at the end of the tunnel. And I think that's kind of been a more recent theme that I'm hearing when I'm doing these hearings, that there's hope again.
I guess I would add that some other aha moments are outside the control of the institution. Regrettably, many of them only discover that they need to begin working on themselves after a family member dies on the outside. And that can have a big impact on them and cause them to reassess their life, whether that's a parent, a sibling, or even a child. And so those aha moments are, of course, beyond our control. Others may have that because they decide to begin participating in a religion. And so as a result of that, they'll start taking that to heart, and it will change their thinking, and they'll become more pro-social and participating in programs, etc. So there are some aha moments that are attributable to factors outside of the institution itself.
And I agree with that. I mean, the turning points for many of the offenders are different. But you see that programming is very important because they're going through the process of internalizing things, and I think it's very helpful. And I think it helps them to get to the turning point. But what I see also that I think is important is family members or support when they re-engage with people. If they don't have family or friends, all the volunteer groups or pastors or someone out there that gives them hope about being released. Sometimes it's, I have an education now, so I can get a job. It's these thoughts that bring them back to the board and want to get released. So then they start working with all the programming. But it's nice to see when they have wives and husbands that are supportive, family members that are willing to help them, and that helps them want to get released, and then they work on themselves while they're incarcerated with all the programming to work on their issues. So it's a lot of different factors put together.
So one last thing, if I may, Mr. Pro Tem, then if what I'm hearing from all four of you, if it is universal and there's a consensus among all four of you, programming does make a difference, or it does make a major difference?
Absolute difference. Absolutely.
An absolute difference, okay. Because I would imagine that when you arrive to a correctional facility that obviously you're angry, you're scared, you're deeply insecure, you're fearful, you're in denial of your crime, and right away, given the current circumstances and the environment that you're in, unfortunately, sadly, and tragically, you have to sort of decide what group am I going to be a part of. They obviously have their own agenda, and whether you're easily manipulated or not, and then you go on years and years and years on until whenever that aha moment comes, whether it's that unfortunate tragedy that takes place outside of the prison walls, a son, a daughter, someone who dies, and you don't get to see him or her, or get to bury him or her, and it's important for us policymakers. Obviously, money plays a big part, and obviously the budget deficit has been very difficult for all of us. But it's good to note that on the record that programming does make a difference. There's a clear correlation for those aha moments to be more part of the culture, more systematic as opposed to individual. Thank you.
Thank you, Senator Daly. And I want to ask one other question. I don't know that I've ever heard asked in one of these hearings with the Board of Parole hearings, and that is the role, if any, that notoriety of a crime plays in your decisions. I mean, there's some crimes that are so high profile, so well known that, regardless of the record, rehabilitation, it must. I just want your
well, they're certainly
thoughts.
Challenging, perhaps because they do bring more interest, but typically those high notoriety cases occurred because the crime itself was particularly atrocious.
That's well, I got it.
And the law allows for consideration of the gravity of the crime, the number of victims. And so in some ways the law allows us to consider exactly that because that is a factor, and that typically is what brings the case high notoriety. But you're right that the process is the same. We consider the input of all the stakeholders the same, and we probably just work even harder to make sure that we're prepared, that we're thorough, and that we address the public safety issue fully on the record.
Anybody else? You don't all have to. Ditto.
I disagree. I think that it doesn't. It doesn't have an impact on the final decision. I had a case in the Valley where 2020 or 60 Minutes or somebody filmed the whole thing, which I didn't know in advance that they were going to be doing that. And so that added additional pressure and sense of the audience, but it didn't make any difference as far as, our final decision. So, they're all high-profile cases in my mind. Anytime you commit a murder for no particular reason, then it's, a serious matter, so.
Yeah, I've had Gregory Powell, and I've had Tex Watson. Both those cases were pretty high notoriety crimes, and you just prepare it the way you do the other cases, and see if they're suitable or not. I mean, you know what the case is, but you just got to take a look at really what the factors are that are involving public safety.
Right, and I wanted to reemphasize that it's really about the suitability factors. The notoriety comes in as far as the process because of all the other people that are involved in the process, which normally doesn't happen for a hearing. So a lot of times they end up being longer. But as far as going through all the factors and determining suitability, it's the same standard for the high notoriety versus what would be considered the other cases.
Okay. Let's hear from witnesses in support of the nominations. Yes, ma'am. We have a mic right over here.
Thank you. My name is Vanessa Nelson. I'm speaking for Life Support Alliance. We advocate for the increasing release of prisoners on parole. We'll be speaking today, our comments today really are more empirical and on point than usual due to the recent decision to allow observers into parole hearings. We have observed most of these particular commissioners at hearings, and so we're really able to give you a critique of what we have found. While we agree completely with the commissioners that program is extremely important, we do want to add that it is not nearly available enough in all the prisons or thorough enough in all the prisons. And we also have it part of our mission to make sure that everyone, including the public and legislatures, know that life-term prisoners released on parole by the Department of Corrections' own figures recidivate at less than 1%. We are in support of Ms. Fritz, not because she has an overly generous parole rate, but having had the opportunity to observe her actions, we find her to be thoughtful and to be attentive to the mandate to consider the present circumstances before her. And this cannot be said of all the commissioners. We support Mr. Mosley's confirmation. We feel that he has a deliberation process that is undertaken with an eye toward legal principles and findings, and believe that his legal background, while it may prove challenging to some attorneys, is of overall benefit in weighing the information presented. His interest in facilitating the amount and breadth of commissioner training is also a very positive approach. We find ourselves in a split decision position regarding Mr. Peck. We recognize and appreciate his willingness to engage both inmates and stakeholders in communication, and find his decision process is becoming increasingly judicial versus custodial. We also recognize his interest in promoting effective parole readiness and self-help programs within the institutions, but we remain troubled by his propensity to issue long-term denials. Mr. Peck leads the present panel of commissioners in handing out long-term denials. More than 1 of 5 of his denials in the last 8 months has been for 10 or 15 years. So while we are recognizing of these improvements as we consider them, in the words of the commissioners, we find these improvements are too recent to overcome our concern with his long-term denial rate. We support Ms. Turner's confirmation, again, not because of her grant of parole rate, but because we appreciate her efforts to communicate and talk to and not at the prisoners before her. She has an ability to draw out information from men and women who are not articulate and often have difficulty in giving voice to their changed perceptions and attitudes, and these are the evidence of their rehabilitation. She very much recognizes her responsibilities to all stakeholders, and we believe her decisions, even those what we don't agree with, are done with due deliberation. And we absolutely support her statement that the aha moment for many of these prisoners is hope. And the fact that the grant of parole rate has increased overall has given a great deal of hope to a great many lifers. We hear this from them constantly. They are now willing to really put in the work and really do the things that will make a difference in their lives and in public safety. Thank you.
Thank you. It's very articulate testimony. We appreciate it. Are there any other witnesses in support? Any witnesses in opposition to the nominees? Okay. I am prepared to support all 4 nominees. I just note a couple of things. Number one, one of the concerns that many of us have expressed over the years here is that this board have more diversity. And when I mean diversity in background. This is primarily a board of former law enforcement or law enforcement officials. Nothing wrong with that. They appropriately belong on the board, but there weren't others representing other parts of the criminal justice system, and that's changed. On the other hand, I will say all 4 of you have a background as either in and around law enforcement or as prosecutors. And so the concern about grants of denial or rates of granting parole or not is, of course, valid. But within that, you'd have to find, it seems to me, some real evidence of bias in order to not support the nominees. And given the backgrounds, given your answers today, and the way that you, I think, have expressed how you reason through the difficult cases, I think all four are worthy of confirmation. Is there a motion? Any other comments from members? If not, anybody want to separate the folks? If not, please call the roll.
Senators Alquist? Aye. Alquist, aye. DeLeon? Aye. DeLeon, aye. Fuller? Aye. Fuller, aye. Dutton? Aye. Dutton, aye. Steinberg?
Aye.
Steinberg, aye.
I can see I was very persuasive. That's good. No, I wasn't persuasive. You deserve confirmation. We appreciate it. Let's go to the floor. Senator Dutton?
Yeah, I've sat through quite a few hearings with regards to appointees to the Board of Appeals, and this is one of the first times I've actually haven't seen a lot of opposition or support for our appointees. So, I think that's where when I look at something like this, I actually, if somebody's got some problems with somebody's being considered, I actually like to see them kind of come forward and let me know what those problems are. So I think you could probably find fault with, a little bit of fault for everybody, but I agree with what the President Pro Tem has said. The statute actually provides for preference to be given to people with some type of law enforcement background and experience. You all have that, and I am convinced that you are going to try to do your best to make sure that we don't release people strictly because we want to release them. I think you're actually trying to make sure that they've actually got the resources to be successful when they re-enter society. And I hope I'm not misplacing my trust. So anyway, I want to congratulate you all.
Well, thank you.
Very good. Thank you very much. These will move to the floor, and Senate will take up your nominations in due order. Okay?
Thank you.
Thank you.
Thank you very much.
So, members have any questions or concerns about items 2? We're going to remove item 10 or put over item 10 without objection, okay? So any questions on items 2 through 9? Gotta wait for Senators Dutton or Fuller. You guys okay with items 2 through 9? Okay, without objection, we'll take a motion from Senator Alquist. Without objection, we'll substitute the unanimous roll call. We are adjourned into executive session.